address. I think this is it's very important. There are new elements being brought here that the public should have full understanding of and trust in. The last thing we want to do is a good thing with unintended negative consequences we either haven't thought of or isn't exactly what the public was intending or wanted. But I believe if this is truly what it sounds like, there should be nothing but happiness and rainbows here. I have a feeling that we have a neighborhood that's very passionate about its area, and likely, and correctly so, because it is, as in many of our neighborhoods in Miami, in flux right now, and this is the consequential time when we make these decisions that can be transformative, that can be absolutely transformative, and we want to get it right. So, if anyone would like to speak on this item, please line up at either of the lecterns. Is there only just a couple? Because I remember when we sworn in, there were several. Thank you very much. Anyone for the item, please stand over at this lectern and we'll alternate. Thank you, and we'll start, please. Thank you very much.
Sorry, I jumped up here because we do have a pending request for intervener status. My client is FUM, but I'll start from the beginning. My name is Nina Jagannath. Good evening, everybody. My address is 3000 Biscayne Boulevard, Miami, Florida. So I'm here representing FUM in his request for intervener status. There was a previous.
I'm sorry, who are you representing?
FUM, Family Action Network Movement.
Thank you, just for the record. Thank you.
There was a previous letter that was attached as to the agenda items, but that one I've amended, so I'm going to pass out copies for the. The documents that you see there is a statement. Of course, that statement of objections and evidence was based on the previous documents, as I've not actually had the opportunity to review any of the documents. We reserve the right to enter additional evidence, comments, and objections into the record. One of the, attached to the statement at the back, there is a letter with an intervener status request and evidence supporting FUM's standing under the Renard v. Miami-Dade County standard. This letter, together with the declaration of FUM's executive director, Marlene Bastien, provide examples of FUM's interests and those of its members will be disproportionately impacted by a rezoning of this size. Of course, we, again, do not have the benefit of having read those documents, so any additional comments or other information that should be there in there is, I haven't had the opportunity to actually incorporate that.
Mr. Clerk, please hold the clock. We're establishing whether or not intervener status is appropriate in this situation. Could you point me to the page again, please, where you referenced the argument for intervener status?
The letter should be at page 21. And then just behind that is the declaration.
So page 21, Dear Miami City Commissioners, impact of project. FUM meets the requirements for standing and is entitled to intervener status.
Yes. So, well, it's the page after page 20, but it's not labeled page 20.
Yeah, 19 is, well, it was, let's see, 20, yeah, 20 is labeled, but 21 is not.
Yeah,
so,
that's the one
that's it right there, Commissioner. Mr. City Attorney, Mr. Suarez-Rivas, what are, for the record, the criteria under which we grant or deny intervener status in a situation like this, please?
Well, the dispositive case, Renard versus Dade County, was cited by the council here. Generally, you have to look to whether there's special injury, different in kind and degree than the general public, something that is not a generalized grievance, a generalized objection, or a position. For example, courts look to things like, are you abutting? Is there ownership in the members individually, though that's not really here, that I see anyway, readily that jumps out by someone's name. Does the entity itself have an abutting interest because they're a representative entity? And as a matter of due process, you also want to hear from the applicant simply because they're requesting for intervention.
Obviously, they
Right.
will have the ability to
Right.
rebut and say why they don't believe there should be intervenor status.
Right, so that is what this, the triers of fact have to evaluate, the factors of proximity, property ownership, impact on them in a way that's different in kind and degree than, for example, other residents of the Upper East Side or Little Haiti or Palm Grove or, where, the general area.
Thank you very much.
Of course.
So we'll start with you, please. If you could lay out the case for specific injury that's separate and greater than the general public, as well as from a geographical perspective, how your group is more disparately impacted than the general public.
So, FUM can claim both associational standing, which means a standing on behalf of its members that stand to be impacted more than the general public, as well as organizational standing on behalf of itself for its own economic harm or diminution in membership because people have been displaced from the neighborhood. FUM is a social services organization that's located in Little Haiti. It's on 84th Street. And it is dedicated to meeting the needs of low to moderate income families and children. And many of their members in the declaration, we cite that there are at least there are dozens of members in the zip codes of Little Haiti: 33127, 33137, 33138, and 33150. The ones that the zip code in which the application is in is 33137, 33138. And FUM has at least 30 members that are paying members, and then 200 members and beneficiaries of its programs across Little Haiti. It has also expended significant funds, and I would like to call up Marlene Bastien, who's the executive director, who could speak in more detail about the specific harm that has been done to their members and the organization.
As long as it stays to the realm of standing,
Yes.
I don't want to get into the substance
Yes.
of the issue. This is simply just to establish whether or not intervenor status should be granted.
Mr. Chair, I object, but I think you correctly stated what it should be, but Ms. Jaganu just stated she will talk about the harm to the neighborhood.
And I stated I'm going to limit it to the scope of establishing intervenor status rather than the specifics of the damage itself.
Yes.
And that's important because once we go down that track, you're already acting as the intervenor and making the case basically.
Yes.
So what we're trying to establish is that the entity you represent is disparately impacted, and not in the sense of how of what that impact is, but why it is more than the general public as a whole. Is that?
Yes. If my client can also explain a number of the members that they serve that are in properties that are directly abutting the subject property here.
Object. If those people would have to be here in order to be able, you can't. That's
The actual members of the organization?
the people who she's referring to who live near there, would have to testify in order to be able to establish, attempt to establish that.
They were here.
Please,
They were
let's
here.
don't go back and forth through me, please,
Okay,
just so we
sure.
can keep the order.
So
for the sake
one
of-
under Renard v. Miami-Dade County, one of the factors that can be considered is that one of the people is is in the notice zone. We did have an elderly couple that was here, and they stayed until about 8 o'clock and ultimately had to go home. But they are on 55th and Northeast 3rd. There's another business, another person who was not well and could not come tonight, but her business is on 59th and Northeast 2nd Avenue. And we have represented, I'm a lawyer and we work quite closely with FOM, and I've represented numerous business owners as well as tenants, or provided advice to who had been facing evictions within the neighborhood of Little Haiti. So I too can attest to the fact that FOM has had to respond to these requests, even though it's not been their primary work over the course of the 3 decades that it's been operating in Little Haiti.
Mr. Suarez Rivas, is it precedented to have a group established as the intervener versus the individuals themselves, or does the case law state which way is appropriate?
When you have them, in my view, requesting intervention as a group, I think that they would have to establish the organizational representative standing of the group, because you don't have individual interveners here, you have a group.
Understood, and they have a representative here, and it's about 230 members, all of whom live within the area. And you mentioned zip codes, but please help me out. What sort of proximity to the actual site are we talking about?
So the zip codes that apply to what is recognized as the Little Haiti neighborhood are 33137, 33138, 33150, and 33127.
That's what
Which 33137 goes up to 62nd Street, I believe, is just below the subject property. Above that is 33138. To the west of that is 33150. The south of that is 33127. The notice area covers 33138 and 33137. 33127 and 33150 are further out, but are still considered to be within the Little Haiti neighborhood, and that neighborhood is impacted. You know, the size of this project will likely have ripple effects that go into those zip codes as well.
Sure. So notice, normally we would grant intervener status to someone who's abutting. Raphael, is there a standard, or is it
somewhat? Well, I think that there's been a recent case that's further clarified that, but it is a Renard versus Dade County rule. So in terms of zoning, it's under the Chapter 62, people, for example, within 500 feet of the radius of the property, abutting people, clearly persons that touch and concern the land, people in close proximity, people that, for organizational standing, if something that can be articulated about a particular project or development that uniquely or particularly affects the interests of an organization, factors of that nature, sir.
okay? And in your opinion, have we established that here?
Well, it's up to you as a trier of fact. I mean, to me, I think you have to find, that the entity that is requesting it, Family Action Network Movement, has an interest that's a different kind and degree. I believe the fact that they say they have members is fine, it's taken at face value, but those members are not the interveners, nor are they witnesses.
Correct.
Here.
The group is the intervener,
Right,
if
the group.
so. And does your group represent families throughout Miami, and this just happens to be one section of your group base, or is this group dedicated to this neighborhood?
That's why I'd like to call up Marlene Bastien, the director of Family Action Network Movement, because she could answer the questions about their membership and what they serve better than I can.
Mr. Chair, if I may.
Yes.
I object. First of all, the city attorney has given a very clear and absolutely correct interpretation of the law, both under Miami 21 and the case law with regard to standing. I would like to, so that this procedure does not turn into something that it becomes farcical, though, I'd like to point out a couple of things. Number one, one of the things that has been mentioned by council is the lack of notice. Well, and you received for the first time today, February 28th, we received here for the first time just a few hours ago, this letter purporting to be the argument setting forth the case for standing. It does not contain one single fact consistent with what Mr. Suarez Rivas has laid out as a basis for standing. It is a conclusory statement saying that FAN has an interest in the neighborhood, and on its face shows that there's a lack of standing. There's a lack of notice to an affected party, which is my client, that we would even have to argue this. So
I'm
if
sorry,
they
but-
want,
Thank you. Just one moment, please. Please, just one moment.
If they
Mr.
want-
Suarez Rivas, is there a notice requirement for the party trying to establish standing in terms of what they submit?
No, the city has not, to my knowledge, ever adopted a regulation providing for that. It's maybe been discussed, but it's basically done or tennis at these public hearings. We don't have a regulation that says, 5 or 10 days before you have to,
And I would like to say for the record that a previous version of this intervenor request, which is substantially the same, was entered into the record before and is included as an attachment to the agenda item that anybody in this
Well,
room could look up if they wanted.
you were not granted intervenor status back
It
in
was a
November.
request. The
You
letter
spoke,
requesting.
You spoke, and you did not either you did not seek or were not granted intervenor status at that time.
I don't recall voting on intervenor status about this this entity.
I
believe this is
did.
the first-
Perhaps
Comments. It was in my. I did ask for it, but then because the item was being continued, I decided that I would argue it at the actual
Got
hearing.
it. So
may
what
I
we
finish, Mr. Chair, just a brief, like a little opportunity before we go into longer testimony to rebut. Zip code is by no standard a standard that is judged for determining the intervenor status. Zip code could mean you could be a mile or more away from the particular property. When this city commission has considered it in the past, it has been someone who, as Mr. Suarez Rivas has said, is an abutting property owner right next
Correct.
door. Someone who therefore might be affected by what is proposed.
correct.
A general group of people, some of whom live in the area, some of whom don't, does not qualify for intervenor status by any means.
That's well noted. I would argue that normally under our planning and zoning, we're talking about a garage coming in or a building going up, and then we look to the neighbor most directly affected by the shadow or the impact or the traffic that they create. It could be argued that in an area that is quite relatively quiet compared to what's about to come based on an SAP of this size, with over 2,600 units and over 20 floors, that the direct impact, that abutting group, possibly could be considered the intervener to that project. Now, it's not solely up to me to make that decision, but it's our job right now to simply establish whether or not they qualify for that. But I do believe there is an impact to the direct surrounding neighborhood, for sure. Whether or not your group represents the, we'll call it abutting or disparately impacted group, is what we're trying to establish. So, without going into substance, and with due respect, we should not call this a farce, because this is very serious. And these are people's lives. They may not be interveners. They may be here for public comment, but they are afforded their due process to establish that. So please continue.
I appreciate that. And before I call Ms. Bastien here, I just wanted to say for the record that we are claiming both associational standing on behalf of the members that live in the surrounding area of the SAP area, as well as organizational standing on behalf of FAM for the resources that it has had to expend to respond to the needs of its members as a result of many of the both this project and the other development pressures in the neighborhood.
I object, and
Your objection.
if I may, and note my objection and move to strike that from consideration, because again, there's not one single specific fact in support of the argument that
I'm
has been
calling
offered.
a witness for that purpose.
I'll overrule for now. I want to hear what the case is, not the substance of the impact, but how you are disparately impacted from from the rest of the city. Why are you more directly impacted from this project? Because it seems to be that that is the standard that would grant intervenor or not, and then obviously the proximity. And so, Ms. Bastien.
Marlene Bastier of Family Action Network Movement. Thank you for this opportunity to discuss what has been happening to our members for the past 18 months. We've definitely seen an uptick in a number of renters and businesses that have been pushed out of the neighborhood.
Please, this is
Yeah.
getting into the substance of the impact and the case you would make as an intervener. Try to help me state purely on the legal lines of that intervener status. Why are you more affected than others, and why is it you and not someone else as a group?
As a result of this uptick, a lot of business owners and renters and homeowners have been coming to our agency seeking assistance. And we've had to divert resources, human resources, financial resources, to assist them. Just the other day, we had an entrepreneur whose business is located close to Magic City, on 59th Street. And as a result of the developer who owned the space that he's renting, increasing his rent by $1,000, and then closing the door of its business with all his merchandise inside of it, firm has had to divert human resources to assist him, to negotiate with the developer, and to even put forth financial resources to support him. Otherwise, he would have lost everything that he possesses. This is one of many examples.
Mr. Chair, I object, a standing objection.
We'll let you speak.
We have
Just a
not,
moment.
no,
I'll
this
hear
is,
the
you're
objection.
now seeking legal status. And I object because this is hearsay and secondhand evidence. There is not a individual standing before us. We have not been told who this individual business owner is, where his business is, how
Sustained.
much it's been affected.
Understood and sustained. Marlene, if you could help me with the group, because what we have to establish is that the group has standing, not an individual within the group, but the group.
But we
Yes.
are an institution, but we represent members who are being impacted by the developments in Lower Haiti. So this business owner was here earlier, like many of the members that we represent. They were here earlier, but they've been here since 12 p.m. and then a lot of them had to go. This business owner was here and he had to leave.
Same
so
objection.
We are talking about people who were here but had to leave.
Understood.
Yeah.
Same objection.
Overruled. She didn't get into the case of the business owner. She was just trying to establish why the business owner is part of the group, and that establishes that the group has standing, if I understand correctly.
But I also further object, Mr. Chair, and
Yes.
I know you're trying to be fair.
I'm trying to be legal.
But again, no identification of who the person is, where their business is, what their issue is, how they've been affected.
Right, but you don't want
adversely.
that actually. You're saying that shouldn't be entered because
Well,
they're
I'm
not.
saying that the testimony cannot be considered because it is.
Without the specifics and without the person present. Correct. But even beyond, it's about the group. Either the group has standing to intervene or they don't.
Well, I would also argue, there are some jurisdictions that specifically give standing to specific groups. For instance, in Miami Beach, the Miami Design Preservation League, the organization has specific standing for quasi-judicial proceedings. But absent that, in Miami Beach and every other city I know, general organizations do not have even if they are neighborhood organizations, do not have standing. It is affected, just as Mr. Suarez Rivas has pointed out, people who are uniquely, individually, separately, directly affected.
Correct, but we do have some leeway. Mr. Suarez Rivas, you did mention that a group technically could have standing if they had disparate impact and more than the rest of the city, and geographically they were proximal.
Right, and I think the case law, the maximum in the case law is special injury, different in kind and degree than that
Of the
experienced by the general public.
the general public.
And but for the organization, let's just say, because it's for the trier of fact, but for the organization, you're right on some of the things you were considering. Does the organization itself own property? Does the organization itself, are they within the zone that gets notice? Are they registered in net to,
How does the impact
so-
differ from other organizations in the neighborhood?
So, and well, it's not from other organizations in the neighborhood. How does it differ from the general public of Miami? Is there a greater impact than the general impact of public of Miami? So, if you could answer those questions, those criteria that Mr. Suarez Rivas mentioned, where is the organization located? Is there property of the organization?
We are located at 100 Northeast 84th Street, and for the past year, not a day is passed without having renters, homeowners, entrepreneurs coming to our agency seeking assistance. And like I indicated, we've had to divert a significant amount of resources
Right.
to assist them. So we are right in the heart of Little Haiti.
Yes.
And then a little north of our office, a dozen businesses recently lost their spaces, and some of them have been doing business in the area for 30 years. 30 years, and from one day to the next, they lost everything. And it is an everyday occurrence at FUM. So,
Thank you.
yeah.
So this is interesting because any one person from your group may not have standing if they weren't directly abutting. But the question is, as a group, does your group have greater standing than either the general public or other groups throughout the city that aren't impacted at all by this project? It certainly could be argued that your group is impacted more than any other group in the city that represents another neighborhood.
I don't know.
Go ahead.
I don't know in your other group in Little Haiti that is more impacted than FUM, because every day we see the impact
Got it.
of the gentrification and the forced displacement of family members, of renters. We even have some of our family members
Yeah.
sleeping in other people's house because they lost the only place they've ever lived in because of the impact of this fast gentrification. And as you know,
Same objection.
Little Haiti is considered the fastest gentrified
Thank you.
area
Yes.
in the nation today.
Sustain. Is there any more information you'd like to give as to the status of intervener, standing of intervener?
Well, I also just wanted to ask, because organizational standing under, it's a Supreme Court case, Havens Realty Corp versus Coleman, that says that if an organization has to divert significant resources to respond to a, if it can claim injury on basis, then it can claim standing. And I think based on what Ms. Bastian had said, there's ample evidence to prove that. And in addition to that, I still argue that they have associational standing because there were members who are in the notice zone, the 500 feet zone of the SAP area, who were present here. The business owner about whom she spoke earlier, his name is Eddie Mercure. He was here earlier. He's actually on tape, having given his statement at a press conference about what has happened to him. And if we need to supplement the record with declarations and, other evidence, I am 100% confident that we can do that, because I myself have met the members of FUM, and I myself have helped some of the members of FUM that are in the immediate vicinity of the SAP area.
Thank you. I understand. All right. So I do see the potential for intervenor status here. It is obviously a motion of the body. We do have a quorum here. I need a motion from the body to either grant or deny intervenor status, please. Is there a motion from the body to either grant or deny? Because we need to make a finding here as to whether or not they have standing.
And really what the body is doing is just based on what you've heard, in a nutshell, that you feel that the association here, the Family Action Network movement, has an organizational standing different in kind and degree than the general public. Again, the general rule that you heard, based on what you heard and limited to that, and you as a trier of fact determine that, and then you move on.
Would you agree with the further case law that she cited regarding the associational standing?
I would say that that would require an evaluation of the budget of the organization, how their resources are spent, and how it has been diverted in a manner that is not contemplated by them if they are, in general, a social service agency.
But just to understand that statement, Raphael, if the impact hasn't happened yet, they would not have expended the funds yet, correct?
No, because under the case, she said that they have expended resources and funds. So the case is that to establish a standing, as I understand that doctrine, is you've already diverted your resources. You already, because of this, are expending funds.
And based on that criteria, has your organization expended resources on this particular project based on your proximity and just the interest?
Well, we've had to assist some businesses that were facing immediate eviction. Yeah.
Objection. Again, we're getting general statements, no facts, no specifics,
Overall,
opinion.
I'm simply asking if there was financial expenditures of the organization with regard to this project. Has your organization been caused to expend money based on this project? The coming of this project, the planning for this project?
Of course, we've had to expend money. We've had to organize meetings to inform the community about their evictions, how to get support against their forced evictions. We've had to...
Objection, there have been no evictions on our property because there were no tenants on most of our property. She is conflating...
Sustained.
I
understand what you're saying. There was nobody displaced from the property of the project itself. What is it that you're... please, sir, you will absolutely have your opportunity. You will absolutely have your opportunity. This is their opportunity as a group to refute that statement.
If it would just be helpful to do this direct examination style. In relation to the Magic City SAP, has FUM expended any funds to respond to the application that came out?
I object to the relevancy of that. Whether FUM's expended funds is not a harm individual to them.
I'm going by the criteria laid out by the city attorney that if this group has expended funds with regard to this project, it may establish them the associational standing.
I don't think that's
Been requested by their members for additional information on the development pressures in their neighborhoods, why they're seeing an upward impact on their rents, why are they seeing an uptick in evictions, and because of that, FUM has had to direct resources towards explaining, to canvassing, talking to people in the neighborhood, organizing meetings, providing food for people, providing so that
Understood.
they can
Clearly,
understand
you have
what's
spent
happening
funds,
there.
and you believe it's due to their project.
again, Mr. Chair, because this is a serious matter.
Absolutely.
Again, totally non-specific. If they wanted to present a case on it, they would need to come in with specific evidence saying this is how they're harmed, this is how much it cost, this is who was harmed, and this is who we had to help. We have heard none of that. There are, by the way, a number of other organizations in Little Haiti that provide service directly to Little Haiti, which if you were talking about an organization in the neighborhood that would have greater standing, if any organization had standing, they would. For instance, Notre Dame de Haiti, which is the parish right across the street, which provides probably more service in Little Haiti than any other organization. They are across the street. They are located on 84th Street. They service people not only in Little Haiti, but throughout and beyond Little Haiti. We don't know where their members are from. We don't know what's been spent. We have no specifics to support the fact that they are specially affected.
But when they try to give specifics, you object to the specifics being offered.
They're not giving specifics. They're saying they spent money on meals. Mm. They did not say that we. They haven't given how much money was spent, when it was spent, why it was spent, what the event was. Just this is a hearsay general statement, which there's no way of verifying whether what they're saying is true or is not true. It's a different story if someone says, I live right across the street, this is my address, you can check it on public record. But to say they spent money on meals is
thank you. Do you have any documentation of the expenditures of the organization?
We do, but we don't have it right here as we speak. We do. For the past 18 to 24 months, we've been having meetings every other Thursdays. Last Thursdays, for example, we have members coming concerned about their forced evictions. We had renters coming to seek assistance. Every day we have members coming. We have families who have been displaced, who lost their place of living, coming to seek assistance, who do not have a financial report with us right now.
How long will it take you to put that together?
This is something that we can get.
How long will it take you to put that together?
A few days.
Okay, so it's not something you have on a computer or on your phone or anything you could produce for us this evening, even if we tabled it for a little bit.
Exactly.
Okay.
I asked the witness a question, Mr. Chairman.
You can ask me a question.
Well, it's cross-examination, it's my right. Please identify, you just mentioned an individual who you had to help. Would you say who that individual was and what the problem was?
Well, he was here, like I said, he was here, Eddie Mercure was here earlier. He's been now renting for the past 3 years.
Where?
His office is right on 59th Street, close to your project.
Was it in Magic City?
Pardon me?
Was it in the Magic City property?
No. His office is close. Yeah.
Where?
He rents a warehouse. So he's been paying diligently, but has it been happening to many of the businesses? He was mugged at gunpoint and he was in a hospital. And as a result, while he was at the hospital, his business space was closed with all his merchandises in it. When you went to the developer who rents him the space, right? He was asked to pay $1,000.
Objection.
As I indicated
objection,
earlier.
hearsay.
Overruled. You actually asked her for these specifics. That's
No,
what she's
Mr.
getting.
Chair, I cannot cross-examine this person who she has not named.
You asked for
and a
it. You didn't
locate
name
she
her.
has not
You're
named.
being rude.
Please,
He
everyone,
was not-
please.
He is not here to be cross-examined.
But you asked for this specifically. You said, "What's his name? Why did you spend?"
And he's
what?
not here to be
But
cross-examined.
she established that before.
We-
But you still wanted to know.
Oh, she's going on with more
And
facts.
no. Listen, please. It's not about you cross-examining that person. You're cross-examining the group that expended on his behalf. And so it is fair to ask them, and even if he is not here, they are establishing that they spent the money, and they spent it because of some impact from this coming project.
But that would be on that individual, and with that individual not being here and not able to be examined, there is no way of verifying whether what she is representing is true or not.
Because they've already left, and I think that's why they stopped talking about him earlier, and you asked them again. So I don't think they brought that.
Well,
You
there
asked
should
them.
be, if they're going to make an argument for standing,
Yes.
they need to have the evidence and the facts before the commission. So if they want to present it in the
Yes.
course of making a decision.
Do you have a list of your 200 membership and 30? Did you say staff or?
It's 30 members and 200 beneficiaries.
Thank you. Do you have a list of them and their addresses so we can understand sort of a heat map of where they are compared to the project?
I have that.
Yes. Do you have it tonight?
Yes.
Okay. Yes, please.
How does your organization affected differently from other organizations in Little Haiti?
I don't,
That
the standard,
provides social services to the community.
objection, the standard is not one organization versus other organizations in Little Haiti. It is
It's
the
different
one
in kind.
organization
Stop,
versus
please,
the
please,
general
please.
public.
It's different in kind. And so how is your organization, which is amongst one of many active in Little Haiti, assuming yours is active in Little Haiti, how are you affected differently than those other organizations?
It's, the standard is that the aggrieved or adversely, they have a legally recognizable interest which is or will be affected by the action of the zoning authority in question, that, the, sorry. Intervener means, well, this is under the Miami 21, though a person whose interests in the proceeding are adversely affected in a manner greater than those of the general public. And then, I don't have it before me, I can get the citation from Renard, but Renard also says that a legally cognizable interest is one that is greater than that of the general public, not the comparison is not organization to organization within one neighborhood.
I understand and agree. I would say greater than the general public, this group is adversely impacted more than the general public. So is there a motion to grant standing on this to this group?
Or deny?
Or deny? Thank you very much. A motion to grant or deny so that we may move on.
Can I say a couple of things?
Of course.
Yes.
I haven't heard any facts that have been put that describe a situation that is worthy of standing for intervener status. We've considered intervener status in other aspects where we've looked at properties that were abutting some different zoning changes, and some that were even a few houses down, across the street, a few houses down. Across the street, and a few houses down, those people, if I remember correctly, at some point did not get standing as compared to those who were directly abutting it. We've been very protective of this issue. And I can't put facts on the table, only the attorneys can. FARM is an organization that gets some funding from the city of Miami. So if there are funds that are being spent to educate people about things that are happening within the city of Miami, we're part of that funding mechanism. So kudos to us. Organizations that are for this particular SAP have also spent funding to educate people about what's going on. I think people have spent it one way and the other. It's a very unique situation because, I'm listening to the things that are being put on the record, and I would agree with counsel where he says, look, the importance about being able to test a witness is about due process. To be able to look at someone and say, okay, the only witness that's being put on the stand right now is Miss Marlene Bastien. And there's some things that she can account for, and there's some things that she cannot. She cannot tell us that another person, she can't tell us what another witness said about his eviction or anything of that nature, because she does not, from the first-hand knowledge, know that information. She can say whether or not she assisted that person. She can say how much money she spent in assisting that person. And I would love to know if FARM, is paying the rent for business owners and homeowners and renters within our community. Because if they are, I'm assuming they will have a lot more money than I thought that they had. But, we're talking about 30 as what was described in the record, there's 30 members of FUM. We haven't heard on the record who those members are. We haven't heard on the record where those members live. We haven't heard on the record how those members are greater impacted than the general public in the city of Miami. I would think from the way that it's being put, just from the facts that are here, and I welcome an opportunity for you to add more records, more facts to the record, but that what I've heard is a general impact of not necessarily this development, but of rising housing and rental prices in the Little Haiti community. And so, when I think about those, those facts, those don't amount to me to intervener status. I think there has to be a little bit more that's going to have to be put. It's a little weak. So I'll give you an example. Neil, can you take the lecture for a second, please? Neil, take the lecture.
Yes, Mr. Commissioner.
State your address for the record, please.
180 Palm Avenue, Miami Beach.
That's directly across the street. These are made up facts. That's directly across the street from the subject property. Is that correct?
You want to say yes?
Yeah.
Yes.
These are fake facts. This is not on the record for what's being added. And they're trying to build a 20-story building next to your home. Is that correct?
That's correct.
Please.
Your home is a 2-story home. Is that correct?
That's correct.
And the impact that it's going to have on your home is that you're going to be forever blocked by sunlight. Is that correct?
That's correct.
There's no other home that lives as close to that building as yours. Is that correct?
That's correct.
So the point that I'm trying to make is that he's giving facts that are specific to what's happening in that space. He's a person that she can test. So I say to her, counsel, you can have him to ask questions for cross-examination. And she can ask cross-examination questions. It's called counselor. If members of FUM cannot hold themselves together enough to pay all of us the respect of just being quiet and listening at a time like this, then I'm going to have to ask you all to leave. Because we've had 3 outbursts now from 3 different individuals wearing a FUM t-shirt. That's probably paid from funding that we gave to FUM.
What funding do you give?
We give from
The $30,000 for poverty to buy food for the after-school program?
Mr. Chair,
We need to bring order back to this room, please. We're going to speak through the chairman.
look.
And we are not going to have outbursts from the public. Everyone will have their moment.
Look,
I understand your frustration, but we're going to do this appropriately. The
So-
commissioner is making a point about what establishes standing versus not standing.
personally,
It's an illustration.
I don't believe that there's standing that has been established for intervener status. I just don't think so. But I'm not going to move or make a motion to grant it or deny it. Right? They can continue on trying to establish it. That's what I don't mind hearing the facts. But all I'm saying is that let's be truthful with the facts. Remember, when you raise your hand and you say that you're going to tell the truth, that we expect facts to come out on this record. Because this is a very serious matter. If there are not facts that are coming out on the record, then you can be held liable for the things that you say. This is not a game. No one's playing with anyone here. There are bar licenses, and if you, as a people who have clients, right, the clients should understand that the seriousness of their lawyer's representation of the facts that they're putting on the record is important. I respect every single lawyer that's here. Those that work for the public service and those who work in the private service, in the private. And I think that every lawyer that has come before us understands what's happening here. There's a difference. The difference is that up here on this day this is not the courtroom. And so we know that it's not going to go exactly as it should in the courtroom, and that's fine. But my point is, whatever way we decide on the standing, and I'll let the city attorney really give his opinion on whatever it is. That's not what I'm here for. But no matter what, if there is intervener status or if there is not intervener status, what it gives is for that party to have an ability to cross-examine, to test witnesses, to plead in this case. He has, in opposing counsel, has every right to object to that. But if intervener status is granted, that's what they get. There's still going to be a hearing. There's still going to be evidence that's put on. There's still going to be everything that we expect. It just gives them more time than the public comment, which they've already had, if you can tell. So, one way or the other, I want to hear whatever the presentation is, whatever the cross-examination of the witnesses are, and we can go from there. Because right now, the witness that we have is only one person, that's Marlene Bastian. Now, if there are other witnesses that are going to be called, call them. But if you're asking whether or not there's been enough evidence to put to grant an intervener status at this point,
It hasn't been put.
I personally don't
And I would agree with you. So, do you have the list?
I have
And-
a list.
And something's come to my attention from what the chairman said. I'm sorry, what Commissioner Hardiman said. And I always say that as a joke because this is the chairman's gavel. You can throw your gavel, don't throw my gavel. I made it. I take care of it. You do need to establish that by fact. And we trust you as representing at this lectern, to this dais, that the facts you are giving are correct. It is not required for every member of your group to be here. You are here as a representative of your group. It is not hearsay to say what you have spent on a person and their experience. It could be hearsay for you to say how they feel or what they did or etc. But you can speak for your group. You can speak who's in your group and you can speak to what you spent.
Mr. Chair.
So, if you can provide whatever you can for us in this time, if you need some time to gather, we can enter into public comment and you can come back and we can establish whether or not you have standing. But we're going to establish it one way or the other tonight. So, do you have the information at this moment or do you need a little time?
We don't have, we can gather.
I mean, we're just talking about the names of the members,
Sure,
addresses
I
of members.
have the names and addresses.
What you're missing is the
and-
financial amount that you've
Yes,
expended.
and I just also wanted to state for the record
Yes.
that some of the members, including Eddie Mercure, who Marlene had talked about, were here, but were not able to stay until this moment to give live testimony.
Mr. Chair,
And I'm happy to.
with
send
due
them
respect, I
over.
have not had the opportunity
Yes.
to finish my response. And there is precedent in this city for this question and how it is handled.
Yes.
One that I can cite you to involved actually Miami Design District project. I think Mr. Suarez Rivas was the attorney at the time.
Was there a
Where two people came up seeking intervener status. One person was a directly abutting neighbor, and this commission granted status. The other person lived less than half a block away and was not granted intervening status because that person had no special injury or impact. In other words, just as Commissioner Hardiman was questioning, the shadow or whatever it might be.
right?
This is not a decision to be taken lightly, granting intervener status, because you're conferring on them something that potentially could give them extra privileges and rights that they do not have, the members of the general public do not have.
Correct.
And just think of the precedent. If any time an association on any issue comes before this city and says, we represent this group, we represent this neighbor, we represent whatever it is, we want standing, you have opened up Pandora's box in terms of every organization can make that claim on every land use issue. It's a very dangerous precedent. And as Commissioner Hardiman said, there have not been facts, not hard facts. You know, in this day and age, facts do count. There are no hard facts on the table which establish the criteria that the city attorney so correctly laid out.
Yes, and so in the past, and the one you stated was not about a group or association, but rather an individual. But I understand what you're saying. One had it, one didn't. But when in the past, when we have asked them to establish standing, we ask them questions, just as the commissioner said, and they're responded, and we take them at their word. We haven't asked them to produce documents and produce lists and maps and things such as that. If I ask her if her group is within the abutting area, and she has so many, she's told me yes. She's told me they've expended money. She has told me that her people are, her group is affected much more than the general public, and for that reason, I believe they may have standing. I believe they do, but it is a vote of this body, and I'm simply trying to move us along to a decision.
Mr. Chair,
on
it is a.
If I could-
If I may, if you're a property owner.
Yeah.
And you say, I am a neighboring property owner, that is a fact, that is a matter of public record.
Yes.
That is beyond dispute.
Yes.
An organization claiming generically that it represents people does not have that. Now, even if you talk in the world of organizations, let me use the example of Miami Beach. The Miami Design Preservation League has one specific mission, which is regard to historic preservation. They didn't even have standing until they were granted standing in the city code. But there, it is their job, their mission specifically to be an advocate with respect to historic preservation. This agency is a social service type agency which has many different kinds of functions, operates in many different kinds of areas, and you are going down a very slippery slope if you allow any organization to come up, assert without things that are verifiable and provable, because they haven't brought it.
So,
They have,
so you're asserting that they have the same impact from your project as a group across town?
I am asserting that there's nothing in the record here which can establish that they have an impact. You have no basis on which to grant them.
We have testimonial evidence, and even as I was here, there was a couple that is a homeowner based on 55th Street and Northeast 3rd Avenue that was talking about the
That's
impact.
4 blocks away.
But
And they're not here.
Sorry.
Please,
Sorry.
let them finish, please.
And hold on. And then the
It's about the
project-
group, not the individuals.
Exactly, and as the chairman had mentioned earlier, a project of this size of 17.75 acres, a $1.5 billion investment, is a much larger project that has much greater impact on the surrounding neighborhood than a parking garage. And so I think that is a factor that needs to be taken into consideration, and it is, in fact, one of the factors under Renard v. Miami-Dade County. The type of change proposed is a consideration that needs to be accounted for when granting standing to a party.
All right, shall we? So if you have no further information to give toward your status of standing, I believe the criteria are actually quite simple. Raphael, you have a comment?
No, I just wanted to tell you that you're correct, Mr. Chair, as you deliberate this and make a ruling on it. You're right. This is a hearing where it's not a court. The strict rules of evidence don't apply, but still competent, substantial evidence that a reasonable person would support. While it's relaxed, it still has to be substantiated in some way by referring to a fact, an address, a name. You know, what's not required is maybe you still need the facts. That's competent, substantial evidence. Just wanted to bring that up, and I wanted to give guidance to the commission. In one case, I think years ago, where a court granted organizational standing to the Miami River Marine Group, what the court took into account there for an organization, because it's many times not granted, was they were created with part of a mission to work with and enhance and protect the river. There were tugboat owners, salvage companies, stevedoring companies that were members, and that was one of the undertakings that this group was formed for. So a court considered something like that with organizational standing. I think this commission in the past has also thought about, are they registered in the neighborhood net? So I just wanted to mention those things. Thank you.
Mr. Chair, I'd also like
Thank you
to,
very much.
Mr.
I
Chair,
have-
read into the record. This is from a website description of FON. Its FON's mission is to empower low to moderate income families socially, financially, and politically, and give them tools to transform their communities. It says nothing specific about Little Haiti. And in fact,
Thank you.
it links back to a site that deals with immigration, which apparently is perhaps their main mission. So with respect to the statement that they are a protector specifically of Little Haiti, I think they have failed to establish that.
Might be fair to say Little Haiti has some immigration issues. I'd like to keep it strictly to the facts of the list of people that you have as members and the list of people that you have within the association. And I need the financial information of expenditure. You don't need to supply it to us in a perfect spreadsheet. You need to tell it to us if you can figure it out. Now, what we can do is I will table this for now while we take public comment. You can gather the information over this next time. We have a lot of public comment to go through, and if we can get to it this evening, we should.
Mr. Chair,
Yes.
for me to give you financial information,
Yes.
I have to have my accountant. What
Yes.
time is it right now? It's very late right now.
Yes.
There is no way I can promise that I can get this. You're
I'm
tabling.
tabling it for right now. If it could come back this evening, we will. But at the very least, this evening you should be able to produce us, even by reading it to us, the
Yes,
list of names and
yes,
addresses.
yes.
Thank you. So
Yeah.
if you could gather that, please, we're going to move to public comment.
All right, thank you.
Now, the reason why they're evicted.
The reason why they're evicted. Thank you. Because if it's not related in any way to the situation,
Right.
understood. He's stating if using a person's history of eviction as an impact caused by this project, he would like to know that it establishes that it was actually caused by the project in some way and not by completely external facts. But you don't need to address that at this point. That's just what Commissioner Bort was referring to. So we're good for now. We have a clear path. I'm sorry that took so long, but it is very, very important because it changes the entire course of the rest of this hearing. So thank you.
Just for clarity's sake, I had prepared a presentation. Should I truncate that?
Yeah,
into the
let's
2 minutes?
table that for when you've got the full information. We'll do it all at once, and I think we'll make a pretty easy decision based on standing intervener status or not. All right. Thank you very much.